My name is Ron Drescher. I'm an attorney practicing in bankruptcy and commercial litigation. I'm licensed in Maryland, Virginia, Pennsylvania, and Delaware. And today, I'd like to talk about what a no-asset bankruptcy case is. In bankruptcy, as I've said before, there are really two cases going on. There's a case regarding you and your discharge, and then there's a case regarding the property that the debtor brings into bankruptcy. The trustee is going to analyze whether there's value in that property above the secured claims and the exemptions. For example, let's say there's a piece of property worth $200,000. It's your home. Let's say your mortgage is $210,000. In that case, there's no equity in your property. The trustee will abandon it, and there won't be anything for unsecured creditors. Let's look at a different situation. Let's say you're in Maryland and your property is worth $200,000, and let's say the secured debt is $180,000. Well, you're entitled to a $21,000 exemption to protect your home. So we add the $180,000 and the $21,000, and that's $201,000, which is more than the value of the home. Under those circumstances, the trustee is also going to abandon the home because there's nothing for him to distribute to unsecured creditors after it's sold. Now, let's say the house is worth $200,000, the secured creditor is $160,000, and you got a $21,000 exemption. What the trustee would probably do is decide, well, I'm going to probably have to pay a realtor 6%, and I'm probably going to have to pay 2% other closing costs. That's 8% less that's about $16,000 off the $200,000. That's going to be $184,000 left. I got to pay the $160,000 mortgage. I got to pay you your $21,000 exemption. That's going to leave $3,000 left. Some trustees will sell your house to get $3,000 to pay to unsecured creditors. Other trustees will say, you know what, that's not worth it. I'm not going to go through that trouble because really I may not get the $200,000. That's a judgment call that the trustee is going to make in that case. But if the trustee decides to abandon your house and not sell it, if there are no other assets available because you've used all your exemptions on your personal property and your clothes and your car and your other possessions, then the trustee will say there's nothing there to distribute to unsecured creditors. It's a no-asset case, and I'm going to close the case. Then if you get your discharge and the trustee says it's a no-asset case, then the case is going to get closed. Frequently, the trustee will make that decision immediately after you have met with the trustee 30 to 40 days after you file your case. So you're not going to be in suspense for very long if it's pretty clear that you have a no-asset case. My name is Ron Drescher. I'm an attorney practicing in bankruptcy and commercial litigation. And if you have a question about any of this, I'd love to hear from you.